To help us unpack today's closing arguments in these last few weeks of the trial testimony, we bring back ABC News contributor and host of the Law and Crime Network, Mr. Brian Buckmire. Thanks for joining us again, Brian. Let's start out with the prosecution's closing argument. On day one, during opening statements, the state played for the jury almost in its entirety that excruciating 9.5-minute video of George Floyd as he died under the knee of Derek Chauvin. But they didn't do that in closing arguments. Why do you think that they made that choice? And what was their main message to the jury today?
So, Lindsay, I think they didn't play it for the jury because the video has kind of been oversaturated. They've been playing it so many times and so often that I think the fear is that they could be kind of beating a dead horse, sorry to use the phrase, but that also is a problem. They should have anticipated that, and I think it would have been smarter to maybe play the video a little less in the beginning of the trial and leave it for the end. This is the case, what you've been arguing, that the video is why Derek Chauvin is guilty, and to not play that in its entirety for the jury, especially when Eric Nelson is saying that it's more than the 9 minutes and 29 seconds, I think that was a misstep by the prosecution.
And the prosecution was certainly very meticulous about walking through each element of the crimes that Chauvin's been charged with, especially that top count of second-degree murder. Does that show really what their ultimate focus is?
Yeah, it shows me that the prosecution is here to get that top count of unintentional murder in the second degree. They walk through each and every element as most seasoned prosecutors would do, but they did a great job of weaving in the facts and also weaving out some of the arguments that Eric Nelson was raising, kind of showing why some of them were ridiculous, strengthening their arguments, and showing why each and every element and each and every charge was made out, and not just settling for the lower or lesser included charges.
And we just heard this in Alex Perez's piece, but want to play this again. This is how the state wrapped its case with this final message.
You were told that Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
Regardless of which side you're on, you have to admit that was kind of a mic drop moment. How was that for a closer? And on the issue of the cause of death, do you think that the state left reasonable doubt that it could have been the drugs or heart condition that killed George Floyd?
So a few things there, Lindsay. I heard what Attorney Blackwell said in terms of that great analogy as to using the heart of George Floyd and kind of dispelling that argument while talking about the heart, or maybe lack thereof, of Derek Chauvin. I heard it, but I didn't feel it. I would have expected from Jerry Blackwell to give a more impassioned ending to that, especially on such a passionate case. In terms of the reasonable doubt, I think that most, if not all, doubt, especially reasonable doubt, has been pushed aside here. For the most part, it's going to be the jury walking through the charges and seeing what fits and what doesn't. It's a 14-page jury instruction that the court gave to the jury, and they're going to have to walk through each and every one of those elements. But Eric Nelson was able to raise some strong arguments. The question is, are those arguments going to uphold the prosecution's large number of witnesses and testimony in this case?
And let's turn to the defense now. We heard so much about that so-called reasonable police officer who may have had more information than the bystanders can see or what the video can show. How well would you say that the defense argued that, judged by the standard of reasonableness, Chauvin is not guilty?
Not well, in my opinion. I'm not quite sure what Eric Nelson was attempting to do. When I represent someone as a public defender in Brooklyn, I am representing a person, Mr. Smith, Miss Jane. I don't represent this hypothetical reasonable officer, and I thought that was a big problem with Eric Nelson's closing arguments. He seemed to distance himself from Derek Chauvin, only talking about Derek Chauvin and what he did in terms of approaching the vehicle of the officers, seeing the scene, and then move to this hypothetical reasonable officer, never really making the connection between who he was speaking about and what actually Derek Chauvin did. And I think that was a big misstep by Eric Nelson. It made it seem very sterile and not very much like he accepted what Derek Chauvin did, and that he accepted that it may not be criminal, which is something a defense attorney has to do.
And Brian, after the jury was sent away, defense attorney Eric Nelson filed a motion for a mistrial based on comments over the weekend from Congresswoman Maxine Waters. When asked what people should do if Chauvin is acquitted, this is what she had to say.
Well, we got to stay on the street, and we've got to get more active. We've got to get more confrontational.
Got to stay on the street, get more active and more confrontational were her words there. The judge denied the motion for a mistrial, but indicated that the Congresswoman's statement could be an issue on appeal. Is this a potential problem for the state?
I think it could be an issue for appeal. Very unlikely that it will be. If Derek Chauvin is convicted, the first thing an appellate court's going to look at is just the volume of evidence against the defendant, that being Derek Chauvin. And if it is so much so that that evidence would have proved his guilt, but for or excluding what Congressman Maxine Waters said, they're going to consider this to be harmless error. But I think it is very dangerous for anyone to be throwing out that type of language while the jury is deliberating, because even if we get a conviction today, and that is what many people are hoping for, praying for, looking for, that could easily be undone because of the words that occur during the deliberation. So if you want this verdict to stick, you've got to be mindful in what you're doing, not only in the court, but outside the court, because Eric Nelson is listening and he's going to try to push for that mistrial.
And Brian, just one last question to you. You may not know the answer to this, but how late are the jurors able to deliberate until each night?
So the jurors are going to be able to deliberate until 7:30 p.m. Central Time each night. At that point in time, Judge Cahill will allow them to recess into their own hotel. Remember, they're going to be sequestered throughout the pendency of this case, so they're going to be having long days from about 9 or 9:30 in the morning all the way until 7 or 7:30 p.m. But if we get a verdict later on in that day, Judge Cahill has told us that he's going to hold that verdict until the next day, hoping to give us that verdict sometime in the morning so that the city, the state, and the country can prepare for that verdict.
Oh, very interesting information. Thank you so much, Brian Buckmire. Appreciate you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.